Welcome to the Lemkin Law Podcast, real talk on divorce and family law matters.
Welcome to the Lemkin Law Podcast, real talk on divorce and family law matters, where tough conversations meet real advocacy. Hollie Lemkin is a family law attorney and fierce defender of protective parents. If you're navigating a high conflict divorce, custody battle, or feel like the system's not listening, you're not alone. This show is here to give you clarity, truth, and a little fire to keep going. So let's talk about what really happens behind closed courtroom doors and how to fight back. I'm your host, Jon Clemence, and today's episode is What Family Courts Get Wrong About Protecting Children. Hollie, welcome to the podcast.
Thank you. I'm glad to be here.
Yeah, I'm glad you're here. I'm excited to talk about this. So let's go ahead and jump in. So the first question for you, what happens when a parent genuinely fears for their child's safety, but the court sees it as drama or exaggeration?
There's a couple of options that can help educate both the parent and the court at the same time. And the suggestion that I would make is having the court order that the child see a psychologist or psychiatrist, whichever, and have that child interviewed so that it's, first of all, it's a neutral third party. It's a psychiatrist or psychologist. It's not the parent. It's not the court. So you've got a neutral party interviewing the child and bringing some mental health professional experience to the situation. If the mental health professional decides that, yes, this child has reason to be concerned and is, reasonably apprehensive for good reason, then the court, that mental health professional can make a report to the court and educate the court about the situation, so that the court has to step back and say, well, I guess the mother had a right, or the father, whoever's bringing the issue up, had a right to be concerned. And if not, then it becomes an issue of me stepping in with my client at that point and saying, I think you need to get some help professionally, psychologically, so that you learn not to be fearful for your child, so that you can get through this and not put that burden on your child. And that's the bigger issue, is a lot of times when parents become very concerned, overly concerned about their child and the way the other party's treating the child, they start to put that burden on the child, which is not what's in the best interest of the child.
Yeah, I hadn't thought about that, but yeah, if you, it could be the parent in that situation that might need a little bit of extra help to get over some hurdles.
Yeah, and conversely, it could very well be that there is a reason to be concerned. And if that's the case, then that needs to be addressed by the court, appointing permanently a mental health professional for the child to let the child process through those feelings and those issues with that parent, and to then also make a custody and visitation order for that child that's appropriate given the dynamics of the situation.
So that's a great, I love that solution, to get the third party expert in to really help understand what's going on. But I talk with a lot of lawyers, and they are very big on documentation. So I was wondering, in this particular case, would there be any element of the parent needs to document some of their concerns to be able to present them to you or the court?
Oh, absolutely. If they've kept a diary of any kind, before coming to see me or before filing for the dissolution, or if it's a change in custody, that if you've documented, you've kept a diary, or you've got, let's say you took the child to his own pediatrician, and that pediatrician documented an event or issue that the pediatrician thought was difficult and needed to be addressed. That's good documentation for the court. Keeping a diary of what the child reports to you, what the other parent is saying in your presence to the child. So there's a lot of different inputs in that analysis, and it's not just one thing. It's kind of a whole, package of what information you can document. Is it from the psychiatrist? Is it from the doctor? Is it from your own observations? Where is all this coming in? And it all will come in and coalesce together to create a picture for the court in making orders regarding the child.
Yeah, and that picture to the court is so important, obviously. One thing that sometimes might happen is, in a courtroom setting, you might have a situation where protective behavior is mislabeled as parental alienation. So can you talk a little bit about what that might look like in a court sitting?
Usually if it's parental alienation and the court is in agreement with what your assessment is, the court will likely order a mental health professional to intervene. There is, for the most part, kind of an unclear dividing line between a legal professional and a mental health professional. And it's, in my opinion, far greater service to the clients and to the court to bring in a mental health professional if these are the kinds of issues that are being raised in the courtroom. I don't have those skills, and I don't want to be looked at as the person making that judgment. It really does need to be a mental health professional coming into the situation. And that individual will hopefully then write a report to the court. There's the documentation again. Write a report to the court saying it's warranted. The other parent is not being appropriate, or no, it's not. And we've got to get the situation looked at from a different perspective. What is guiding this? What is causing this? If it's not the other parent, then what is it? And how do we solve for that problem? And there's a lot of other ways of things that it could be besides the other parent. It could be a grandparent. It could be a teacher. It could be a lot of things that's causing some problems that need to be addressed.
So I do want to break it down a little bit into more detail because I know that gender plays an important role in how people perceive one another. So in your experience in the court, how does gender play a role with credibility and intent and how those things are perceived?
It's an interesting question. In the courtroom, and it used to be more so than it is today, we still have a little bit of residual bias, but fathers are not looked at as being the caretakers. It's still traditionally that the court looks at the mother being the caretaker. And that does, if you're representing father, you have to work twice as hard to prove to the court that you are a not only good provider of your children, but you're a great caretaker parent. You can consider their needs. You have a good relationship with the child. You're connected to the children, and they come to you as well as to mother, but they also come to you. So you have to work twice as hard, I'm being honest, to get the court to see that this is what your client's made of. This is what's important to your client. Mothers on that topic have a much easier time of it. They can more easily show the court that, well, I gave birth to them. They're my child. I love them. And that isn't you don't have a big fight or a big battle about that. But I mean, I'm just being honest that if you represent the father, know that you're likely to be in for a bigger battle.
Yeah, I can confirm as a father, there's definitely a different in how some people view fathers and mothers. Whether it's right or wrong is kind of indifferent. It just is how it is. So you just have to deal with it. And so with that, with the credibility and the intent piece, sometimes people feel like they're not being listened to, or maybe even being dismissed or gaslit by the system, even if they feel like they have evidence on their side. So what are some signs that you see or have seen in the courtroom of a parent not getting their voice heard by the court?
Usually the first indication for me in a courtroom, if that's happening, is that the judge will start asking questions that inform me that, wait a minute, I've got a problem with my judge. He isn't taking due consideration of what my client is saying. He's not giving it the proper weight. So at that point, it's turning up the heat, and so that the court will get that this guy is a good guy. He has a good, strong, bonded relationship with his children, and it's my job at that point to step in and start really turning up the facts and the information that I give to the court to show them he's an equal parent, if not a better parent than the other side. And that's really where I step in. That's where my training and skills and experience step in and really help the client's perspective be accepted by the court.
I see. So it sounds like the important piece of the puzzle is if you're feeling that way in the court, you need to tell your lawyer so they're aware of how you're feeling.
Absolutely. You need to tell me. And if I haven't already figured it out, because I'm usually pretty good at picking up on that kind of questioning coming from a judge, that it tells me this is why he's questioning. We need to turn up the heat. We need to get more factual information to the court through testimony, through documents, and through a lot of different ways. I mean, who brings the child to the school the most often, who drops the kid off for school every day, who's the one that picks him up, who's the one that sits with him at night and reads him a book, that kind of factual information that can get to the court where the court has to take a second look. And I've had judges in their rulings tell me, initially I thought this wasn't a good caretaker parent, and then on second consideration, I've seen through the information that's come in that, yes, he is a good caretaker parent.
Just in talking with you, last episode, this episode, it's very obvious that you go above and beyond. You care about the needs of the child, the needs of your client. You care about justice and for the right thing to happen. I'm just going to go out on a limb and say that not every last lawyer has that same level of sense of justice and doing the right thing. So what if I'm in a situation where my lawyer doesn't seem to believe me or advocate for me? What can I do?
Oh, there's a lot you can do. You can, and there's no particular order to this. You can get a second opinion. You can go see a different lawyer to find somebody that you think will really be more of what the word is advocate, a stronger advocate for you. You can sit with the lawyer that you have and say, hey, this is what I saw yesterday in court. I'm concerned about it for these reasons, and see what kind of a response you get from the lawyer that you currently have. You can make suggestions to your current lawyer or to a new lawyer and say, I want my child to be seen by a mental health professional who can come in and testify about what's going on and the impact it's having on the child. So those are the major things that I would do initially, just to see, okay, let's make sure we're on the right path. Let's test the waters here. Let's, try those options to see if you can't change the tide.
Yeah, and I love that you present options. Like, you're not powerless. You can do things to affect your situation. You can talk with your lawyer. You can get other opinions. But I can imagine it could be very easy for a person to feel powerless in a situation. Like, maybe they don't think they can do all those things, or no one tells them that they can do all those things. So what would your message be to parents who do feel powerless, like the system is protecting their abuser more than their child, or they're being gaslit, or what have you? What would you tell someone in that situation?
The best piece of advice I could give anyone who's in that situation and feels that way is you are never, and I underscore never, without options. You may not like your options. You may wish you had more, but you're never in a zero position, especially when we're talking about children. Courts don't give up on children. That's their main, that's how they're trained. That's what they're told is their main objective, is to do the best you can do for the children. The adults have made whatever mistakes in life they've made or not made. That's not who we fight for. We fight for the next generation, which is the children, to make sure that they grow up to be happy, well-adjusted people, so that we have a society made up of happy, well-adjusted people.
Yeah, and I love that you bring up that the courts have been instructed and taught to basically do what's best for the child, because someone like me who's not a lawyer may not know that. They may have all kinds of ideas.
Yes, absolutely. They think, oh, the judge said it, so it must be true. That's a fatalistic statement that I would never stick with. I'm always the one in there going for, okay, now I can do this. Now I can do this. Now I can do this. That kind of thing. That's always been my approach, and my attitude is, what can I do to fix this, to change it?
Yeah, that's just a great attitude for, literally anything in life, and how much more so for a courtroom case involving, a child and what's best for them.
Right, exactly.
Well, Hollie, it has been super fun to talk to you today and to just learn a little bit more about what you do, how you help people, and what the law actually says. So I just want to say thank you for coming on today.
Well, you're very welcome. I've enjoyed it.
Great. And to our listeners, I want to thank you for tuning in to the Lemkin Law Podcast, real talk on divorce and family law matters with Hollie Lemkin. To connect with Hollie, visit lemkinlaw.com, and be sure to like, subscribe, and leave a review. With that, have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.